Welcome back to Settlement Nation podcast. I'm your host, Courtney Barber, and today we have another installment of your favorite series, Confessions of a Former Defense Attorney, with a brand new guest, James Murphy. But for the purpose of this podcast, we are going by his other name, Jim, from Claggett Sykes Law Firm out of Nevada. Now, Jim is a plaintiff trial lawyer, but he spent 20 years working as an insurance defense attorney with several prominent defense firms, where he handled hundreds of serious injury cases and served as lead counsel in jury and bench trials. Jim has a very deep understanding of the tactics used by insurance companies, bringing a unique perspective to this practice and this episode. And he is here to shed light on defense strategies so that you can secure the justice your clients deserve. So welcome, Jim.
Hi, thank you.
I am so happy to have you. For everyone who is new to the podcast or maybe a seasoned listener, I actually met Jim recently at a Trial Lawyers University event in California. And what is very interesting and different from other people's backgrounds is that Jim actually has a master's degree in United States history, which I put to the test at a dinner where I quizzed him on the American citizenship exam, where he passed with flying colors. Have you always been a history buff?
Yes, I have been. And that was something that I excelled in school all the way through getting the master's degree at UNLV. And can say that some of that knowledge has been replaced after going to law school. They sort of beat that out of you.
Well, I've never met anyone who could pass the I had to study, for everyone who doesn't know, I just studied the citizenship exam. It's like 200 different questions. Jim got them all right without even breaking a sweat. So I was extremely impressed. Another thing on this, do you have a favorite historical film?
Historical films, probably one of the ones that I've liked the most. And it's funny, I was just doing a flight back from Japan and landed on one of the many films that are available from United Airlines. And I stopped off and watched the opening scene of Saving Private Ryan, which I think probably most of the listeners are familiar with. That's one there that Spielberg tried really, really hard to get everything as close as he could and make it as accurate as possible. So I enjoy that one.
Well, it's funny, I was on a United flight the other day and I did see Saving Private Ryan too. And I thought if my flight was longer, I was going to watch it because it's hard once you get started with that film to finish it. It sucks you in. But moving on from that. So when you graduated from law school, did you already have some offers from big firms, or how did you decide that's sort of where you wanted to start?
Yeah, the history connection was important for me. When I was getting the master's degree, there was a gentleman who was several years my senior taking courses in the graduate program at UNLV for U.S. history. And he was an attorney. That's all I knew. And he made a letter of recommendation for me to attend the newly opened law school. And little did I know that he was a pretty significant figure in the Nevada legal community, it's small now, and it was even smaller then. And that was something that I think was important for me to be admitted to UNLV School of Law. And so later upon graduation, it was sort of a natural fit where I could go to work at his firm, which was a Nevada specific or Nevada-based insurance defense firm, which gave me my first job for several years working at his firm.
And so from there, you've had a very expansive career working in the defense. But was there, obviously you got to a point, was there a catalyst? Was there a moment that you remember where you just thought, screw this, like, I don't want to do this anymore? Or was there something that pushed you over the edge or brought you to the light side, as some people say? What was that moment, or was it just a gradual kind of process?
It was a gradual process where I think a number of factors, not one factor being more important than the other, made it such that I wanted to change. But this year, in fact, next month, I'll be turning 50, and thought that if I was ever going to do another significant career change, it had to be now.
Mm-hmm.
And that was probably the biggest one. Also, my wife, who is also an attorney, encouraged me to make that leap and don't stay stagnant.
Mm-hmm. And I think it's great advice for any of our listeners who are maybe have been going down the same path as yourself, prior to now, and they think, oh, it's too late to jump ship and try something new. And, it's a testament, and happy birthday for next month, that you can at any time. And, leading into where we are today, all that amazing experience that you have would only help you exponentially now as a plaintiff trial lawyer. And that's obviously why we have you on Confessions of a Former Defense Attorney, because you today are being able to shed light on a lot of things that will help trial attorneys with their practice, and kind of figuring out how the defense works and how their mind ticks and some of the tactics they use. So for everyone listening, Jim put together an amazing list of topics for us to cover today, and we're already going to get him back for a part 2. So don't feel alarmed that you have to set aside hours of your day. We're going to cover some now and then cover some in the next episode. But I kind of want to start off, Jim, with assumptions that are made, by the defense regarding the progression of injuries. Do you want to kind of go into that a little bit for me?
Yes. I think that one of the things that I, as a defense attorney, and also working with a variety of claims professionals, have operated under the belief that injuries will progress in sort of a linear fashion, where an individual that's claiming, say, orthopedic injuries arising out of an accident may have the typical course of care and go from, say, less invasive modalities where they're experiencing strain, sprain type of complaints onto something that may be more serious. And if those check the box sorts of indicators aren't met, then a person that jumps right to, say, treating with a neurologist or getting interventional pain management care without having a stop somewhere earlier in a less invasive sort of provider may be aggressive, and also looked upon as somebody that hasn't exhausted all of those non-invasive sorts of treatment options that they typically see when you're examining the entire picture of someone's accident-related care.
And let's talk a little bit about surgical recommendations. How is that viewed from the defense side?
Yeah, I think, at least in my jurisdiction, they're looked upon with a bit of a jaundiced eye, whereby the same cast of characters on the orthopedic surgeon or neurosurgeon side, who are typically working with plaintiffs' attorneys and providing, say, treatment on a lien, would be quick to offer a written surgical recommendation. And so those kinds of individuals who are authoring the surgical recs get a reputation in a particular jurisdiction, where experienced defense attorneys, and then those adjusters that are also adjusting the claims in your jurisdiction, are going to recognize those names. And what I've seen now, just in my brief time period here on the plaintiff side, that there's a willingness to think outside the box. If you have that willingness to think outside the box and work with other providers, where possible, you should do that. If you feel like you're using the same doctors and working with them to provide care for your clients, you need to try to break that routine and not put together somebody's care using the same 4 or 5 doctors who write the same notes and use the same language in all of their medical charts. In particular, the language that's used in surgical recommendations. Sometimes you could hold two of them up from two separate individuals that were involved in totally different accidents, different ages, different genders even, and they may read the same because you know that at the end of the day, this doctor's just doing a cut and paste job.
Mm-hmm. Do you have any examples from your time that you could speak about where, you could see these patterns come up in some of the cases that you had from maybe doctors that they're being reused over and over again or that type of thing?
Well, you just said it. I think I can name the doctors, and I shouldn't do that in this case.
Exactly.
But the fact is that you see the same patterns, you see the same language, you see the same recommendation for surgery on what would arguably not be supportable in many cases, say a 1 millimeter disc bulge that a doctor is saying is surgical, and we would typically say that this doctor so and so has never met a non-surgical disc. Right. And so you want to try to stay away from those wherever possible. If you feel like you're not getting any traction with that particular physician in their written recommendations for surgery, then break that pattern and go in a different direction where possible.
That's great advice. And on the topic of assumptions, and to sort of wrap this section up, is there any other thoughts or notes or tactics, things that you could share with people that you've seen that you think, as a plaintiff lawyer now, you would choose different paths?
Yeah, I think I would stay as far away from certain doctors that are being reused repeatedly in your jurisdiction. That to me seems to be something that you would want to stay away from because they have maybe a limited shelf life.
That's fantastic. So let's move on a little bit to attitudes and, of course, plaintiff attorney attitudes towards adjusters. Do you want to give a little bit of an overview of that and what you've seen?
Yeah, I think most of your plaintiff's attorneys are going to have a negative attitude toward insurance claims professionals and look upon them as inhuman and people that aren't to be trusted. I think there's probably good reason for that, for the simple reason that, there may be promises that have been broken. An insurance adjuster tells you that they'll get back to you, and then they don't. And that leads that plaintiff attorney to assume that they're not being given a fair shake and being left sort of out in the cold. And I think that leads most people to have a negative attitude toward adjusters. And so consequently, when you interact with them, there may be this tendency to ramp up the rhetoric and act in such a way that you might feed into a sort of downward spiral in the discourse.
And you did have one of your notes here, in your interactions. What have you seen, as we said, you've been on both sides. Is there a type of attitude or way that you converse or conduct yourself that you think is more beneficial? Because some people go with the very direct, rough approach, but maybe there's something else that works. What do you think?
Yeah, I think that for the most part, no matter what background or what job description or what assignment that adjuster has, they are always going to have a series of responsibilities that they need to meet in order to do what would be the bare minimum or the bare floor for their work assignment in adjusting that file or that claim. And if you can't even give that adjuster what he or she needs in order to not get fired, then you're probably not going to get anywhere, and your attitude toward them isn't going to make a bit of difference.
Mm-hmm.
So when you're interacting with that individual, recognize that individual has a pretty detailed job description that includes getting recorded statements, for example, dispatching an independent adjuster if they're not going to be the one that's directly involved in conducting an investigation of a loss, and getting a report back from that independent adjuster before there could be any real movement in regards to any negotiation.
Mm-hmm.
So if they haven't done what they need to do in order to build their file and correctly document that file, the demands that you may be making on that adjuster are going to fall on deaf ears.
And on that note, which is something that I've always wondered, what is their sort of attitude towards plaintiff attorneys in general? What do they think?
Yeah, I think that varies depending upon who you are. So if you are a plaintiff attorney that has dealt with them in the past, and you have successfully, say, taken a case to trial against one of that company's insureds and obtained a large verdict, there is going to be a different attitude toward you and your firm than, say, somebody that is an unknown quantity.
Mm-hmm.
That is, you could characterize that difference. That difference is one of track record. That's a simple example of an adjuster's attitude that will vary depending upon who that plaintiff attorney is. If she has gone to trial and been successful, they're going to treat you differently.
And is there any examples from your time where you saw this happen, maybe with people's track record of success, or, dealing with new trial attorneys?
Yeah, I think that adjusters do look you up. Adjusters do try to research you. And in my job duties as defense counsel, when the case would come to me, which is obviously, gone through the claims process and there hasn't been a resolution. So typically the case comes to me if there's a serious time limit demand that the adjuster needs help with, or the case goes to suit. They're asking me, hey, what is this plaintiff attorney's reputation in the community? Are they an attorney that takes cases to trial, or are they not?
Mm-hmm.
And we want to know that because we take that into account when we're addressing what we need to do in order to get the file closed.
That's actually a really good point, and just completely separate from what we're talking about. But, as defense counsel, would you be researching the trial lawyers, and you probably know ones in the industry that you definitely know that they have a reputation for going to trial versus ones that that will settle?
I do. And I know that just based upon having practiced in one location, one state for my entire career. So I know who the real players are
Mm-hmm.
In the plaintiff attorney game. And I know who the people are who have no equity built up. And they are individuals that run sort of a mill that don't take cases even beyond filing a complaint.
Mm-hmm.
I mean, there are lots of plaintiff attorneys that don't even know where the courthouse is. And so the insurance professionals that defense counsel will correspond with, the insurance professionals want to know what that plaintiff attorney's reputation is for taking cases to trial, and do they have a significant track record of success, because they're asking you on the pre-printed forms for what we call evals or evaluations. So we have to do, as defense counsel, initial evaluations that contain descriptions of what it's like in that particular venue, what is, as I said, plaintiff's attorney's reputation, and then a variety of other things that you're required to analyze and look at so that you can report and they can move that information up the food chain and act in such a way that they're doing all sorts of important things. Namely, at the top of that list would be setting the appropriate reserves.
Is there an example in your experience where you found out the plaintiff trial counsel and you thought, oh no, this is not going to be good for us, or you were surprised, or you thought this is going to be really interesting because I know they're going to take this case to trial?
Yeah, I used to have a sort of a running joke that if I went up against certain attorneys, I should double my hourly rate.
Right. Good to know. Well, we always on this podcast, we always really push and recommend the listeners to get to trial. And a lot of our top guests that we've had are some of the top trial lawyers, like Nick Rowley and those types of people. And so that's great to know, because we're always saying, listen, you've got to get the practice in. You have to get the reps in by going and trying cases, because that's the only way that you figure out what you're doing, if it's working, if it's not working. But that's the only way to build that reputation too, that you will do it. And as you've just said, the defense knows if you're someone that doesn't do it.
Yes, they absolutely know. And I don't want to repeat myself, but I think it's important to note that as a defense attorney, your evaluation pre-printed forms specifically ask for that info.
Mm-hmm.
So it is a known factor that insurance companies of all stripes are looking at and taking into account.
Fantastic. I love that. Now, moving back to the adjuster, because we're kind of looking at their, archetype right now. And you had a great question, which I love. Are adjusters all created equally?
The answer to that is no. Simple answer, no. They are not all created equally. And what I mean by that is that depending upon what phase your case that you're advancing may be in, you will not stick with the same adjuster. And as adjusters start out in the industry and then they progress in their careers, they get higher and higher responsibility levels and greater amounts of authority that they have. So depending upon, your listeners may be handling smallish cases that would be the kinds of cases that what I would refer to as a frontline or new adjuster may be handling, because they are relatively low exposure. And those frontline new adjusters are the kinds of adjusters that have the least experience. Mm-hmm. And they're probably the most overworked. And so as a result, their level of sophistication and their experience level is pretty thin. And that's something that you have to keep in mind when you're dealing with those individuals. I've even heard, and I don't know if this is true or not, because nobody can really predict the future, but there could be a lot of those jobs in the insurance industry that may be lost to AI.
Oh, really?
Whereby you may be negotiating with or trying to resolve a claim with a bot if the claim is relatively small and insignificant in the future. So we'll have to wait and see on that. But as you can readily imagine, all sorts of introductory or beginning level positions in every industry that's out there is being replaced due to automation. We've seen that in banking. We've seen that in customer service. Why wouldn't we see that also in the insurance industry? So those people that are, last hired are going to be first fired. Mm-hmm. And we know that that's probably something that is coming. And so keep in mind that those individuals, those frontline new adjusters that are adjusting the small PD claims or small BI claims on the personal line side, those people are looking, at maybe even losing their jobs.
I totally agree with you. You see now, I always get fed these ads on Instagram about chat bots or chat GPT for, law, and how it can, do small things in your law firm and stuff. So I definitely see that happening. And if it's not,
why wouldn't the insurance industry be looking at automating that to a degree? And I think that, what we've seen and we know for sure is that the insurance industry is always on the cutting edge of cost reduction. And one of the things that is anybody who runs a business knows that your biggest cost is your people. Mm-hmm. And those are the sorts of things that you would want to eliminate if that was possible.
And there's a note here too about, how teams that have third-party administrators, how are they different to adjusters?
Right. So most of my work in the last however many years has been for large corporations, large businesses, and those are what I like to call sophisticated insureds. A sophisticated, large insured is going to structure their insurance picture much differently than you or I will when we're shopping for insurance. And one of the things that they typically employ as a strategy to cut costs for their insurance premiums is to retain some of their exposure, if you will. So a large business or a large corporation may have its insurance kick in after the first $1 million. And so that initial $1 million or initial $250,000, it just all depends. And you can price that differently when you're dealing with a producer. That will be administered like it is a layer of insurance through insurance professionals and businesses like Sedgwick, Gallagher Bassett. These are big names that your clients are probably familiar with. Your listeners are probably familiar with. And those companies are just like insurance companies that employ adjusters. They just have adjusters that administer the claims that are within a self-insured retention for a particular business or insured. And I can think of tons of examples, and they're all household names that employ this strategy. And when you're dealing with those kinds of adjusters, they're going to have a higher level of sophistication. They, for example, will only adjust those claims against that particular large national insured. So a third-party administrator is typically going to employ adjusters and group them together in what are called dedicated teams. A dedicated team may be adjusting claims only against one defendant, and they're doing that regionally, potentially, or they're going to be working on behalf of, say one company only. The reason that's important is that they actually know the business of their insured. They understand if that company that you're suing as a plaintiff's attorney is a rental car business or is a drugstore or is a chain of retailers or is a fast food establishment or a trucking company, or they understand how that company works on a day-to-day basis. They may even know some of the key employees. They have a different sort of connection with their insured that an average adjuster does not have. Mm-hmm. And their reporting requirements are going to be higher and greater. The reason is that there's going to be someone like a client representative who could be on the client's in-house legal team that's looking at their reporting and is monitoring or peeking in on the progress of hundreds of claims that are progressing throughout the country against the company. And as a result, they have to do things in a more organized fashion and frankly better because they just work on one thing, and when you work on one thing only, you get better at it. Mm. And so their clients or their insured's expectations are something that are going to be paramount at all times because they only have one set of guidelines that they have to adhere to.
Well, I hope everyone has been listening intently because this is why we have Jim on. He is just sharing all the insider scoop from the other side. Now, before we get on to coverage issues, I want to ask you a couple questions about being a new plaintiff attorney. What was the most surprising change or difference other than billable hours that you kind of discovered as you changed careers? Well, not careers,
Yeah,
but sides.
I think at the firm that I'm with, the firm that I'm now a part of adopts a team approach, and it is what as a team approach, you might imagine that entails a lot of collaboration. So when there's going to be some major step that's taken in a particular file, because the files that we're working on here are larger and significant loss type claims, we're taking things incrementally and slowly and making sure before a move is made that we've thought about it and considered it and kicked it around amongst all of the team members. When I was working on 85 files for a variety of different defendants that have been sued, and I'm expected to generate, the billable hours that I have to generate, in addition to all of the other things that I'm required to do. There isn't time to go and discuss this with individuals. At most, you might stop another attorney on his or her way to, grab lunch or something and have a chat with them for 1 or 2 minutes about a particularly thorny issue. That's not the way that we handle things on this side now. There's meetings that are cooked into the way that a claim is being handled, where important decisions are being discussed and thoroughly thought about before any real moves are made, which I think is important.
And what have you found to be the most enjoyable or interesting aspect of working on the plaintiff side?
Recently, I moved to the plaintiff side, as you pointed out, and I've gotten some interaction with individual clients that I think has been good for me to continue in this sort of journey that I'm having in adjusting my way of thinking toward being a plaintiff's advocate. And so as a result, when I listen to folks that have suffered a loss, like the loss of a loved one in a trucking accident, and I get to absorb some of the things that they can recall about their loved one. And I'm thinking in particular about this case that I have right now, sitting with them in their home and listening to their stories about their son who was killed in a trucking accident. You get to know that individual even though you've never met them. And not that I needed to, but I did visit that individual's cemetery, and it just helps me get in touch with somebody and realize that this is something that I'm working on, and it's a real important case that I need to think carefully about. Like, it goes back to that point that I just made a moment ago about the team approach. If you're making quick decisions that aren't well thought out, there could be implications. And so we're taking it slow. We're understanding what we need to do, and we're making sure that we're doing everything that we can to advance this claim in a really significant large loss type case.
That's fantastic. And, we're going to cover a little bit more of that when we get to the light and dark aspect, but we're going to transition now to coverage issues, which I know a lot of the listeners want to hear about. And one of the first questions that I want to ask you is, can a plaintiff lawyer do a better job of understanding coverage nuances that will impact recovery?
Absolutely. I think that this is just my observation, because I have worked directly with insurance companies for so long, and I've been butting heads with plaintiffs' attorneys that come from a lot of different backgrounds, and their levels of sophistication, if you will, varies just like the levels of sophistications of the adjusters we were talking about. Most of your plaintiffs' attorneys out there in the universe do not understand the important aspects of insurance coverage and how that governs where a case may go and will impact your recovery. Mm-hmm. I don't think that there are a lot of plaintiffs' attorneys that really grasp that significant aspect of litigation, frankly.
And let's talk then a little bit about discovery and understanding coverages, because from what you're saying, that people may not be as well versed in this as they should be, or could get a lot better at it.
Right. And so what I was hoping to discuss was a claimant should demand that they be provided evidence of insurance and clearly understand what insurance coverages are available before making any important decisions about resolving a case for a particular dollar figure. And I think this is done where there may be demands for, say, declaration pages to be provided. And that typically happens automatically when a case goes to suit because there are self-disclosure requirements. But if you're not emphasizing that heavily and making sure that you understand the insurance picture of a particular defendant before making any major decisions in a case, that's something that has to be well thought out. Mm-hmm. And honestly, there's a number of things that can arise that make that difficult.
And when we speak about layers, why are they so important when we're talking about coverage?
Yeah. What I mean by the term layer is a typical sophisticated insured will get coverage through its broker from a variety of companies. And also the insurance is available on the open market, and they change all the time. So depending upon when a claim has arisen, for example, there may be different coverages that are available. And that disclosure requirement should encompass a full disclosure of all layers of insurance, meaning information that you would want to obtain should cover, the term would be a tower. A tower of insurance coverage could, in some cases, in some of the cases that I've handled, go up to 12, 13, 14 layers. And depending upon the significance of the claim that's being advanced, layers 1 and 2 may even be exhausted before you can make a decision about how you need to move forward. You need to understand that.
Mm-hmm. And this is such an important topic, especially for our listeners, but for all lawyers. What other advice or information do you have to share? Because you've spent a lot of time working on that side. I'm sure there's so many things we couldn't even cover in one podcast. But, if you could speak more on this topic, I think it would really benefit everyone.
Right. I think there's something that may be lost on plaintiffs' attorneys when they're making their negotiations and their demands. If you have properly sought out and understood the defense insurance coverage picture, then you could style your demands and style your, say, for example, the service of an offer of judgment and whether to extend out the time limit on that offer of judgment, to leave it open, so to speak, while there is consideration of your settlement overture in such a way that you could encourage layers above the layer that you may be negotiating with to get involved and serve what are called hammer letters on the other insurers and demand that they resolve these cases at the number that you've selected.
Mm-hmm.
And what I mean by that is, for example, let's take an example that I had for a national rental car company. That national rental car company retained the first $10 million of all risks, meaning that claim, if it was to be resolved, and you were going to resolve it for anywhere between $1 and $10 million, that was all coming from that defendant out of its pocket. It was not coming from an insurer. Yet, when you're making unreasonable demands that are $10 million above that layer, there's really nothing that particular adjuster that's adjusting only for that self-insured layer can do to control that outcome. Then later on, when that tension may be created, you could create tension for the defense and the layers on up and down that chain by making demands that fall within a particular layer, excluding ones above. And you'll start to see finger pointing and hammer letters that will be served. Basically, that layer that's above the self-insured layer may be writing and saying, you need to go get this done so that our limits aren't implicated now while you have the chance.
Mm-hmm. That's super fascinating. And just on a separate topic, but, what are some mistakes that you've seen plaintiff attorneys make in this area yourself, or just in any area? And as I said, this is not a super long podcast, so I'm sure there's a whole episode we could do on mistakes that you've seen plaintiff attorneys make over your career. But maybe in this area, is there something that you've seen people do that now you can kind of look at it and say, this is not the right way to maybe approach it?
Yeah. As most of your listeners probably have seen or experienced, there will be on a long drawn out claim, there will be a number of different instances in which settlement may be at hand. And when those demands don't fall in a way that can trigger the key decision makers with the ability to resolve your claim, then there's really no choice, is there? So I'm thinking, there may be layers of coverage that's available, and oftentimes those layers that are above that primary layer may retain their own defense counsel. I've been retained in a number of instances by separate insurers, ones that aren't really footing the bill for any of the defense costs, and they're just there for purposes of evaluating whether the exposure may run into or exceed the primary layer. And those people may be the ones writing the hammer letters, or, for example, advising those carriers to get aggressive against their insured. And if you're not thinking along those lines, then you're not giving them anything to discuss.
Mm-hmm. That's great advice.
I saw that mistake made by a plaintiff's attorney in failing to ever make any demand that fell within that primary layer. And so therefore there was never a discussion that needed to be had. And because that primary layer never valued that claim that high, they're holding all the cards. There's no contribution that has to be made by the layers above if the one below is not tapped or exhausted.
Mm-hmm. Fantastic. Now, on to our next topic, which we're getting so close to the end. So, which I'm really actually happy that we have so much to cover in the next episode. So everyone, this is not the end, forever. We're coming back. But you spoke a little bit about this before, saying you had a story going to the cemetery and speaking to a client's family. You're now on this side and you're seeing that human element. But the question, between that black and white, light and dark, do you want to talk a little bit about that and towards attitudes of, what plaintiff attorneys think of the defense and vice versa?
Right. I think I've heard it now more times than I've ever heard it in my career, just in 2023, since I changed sides. I heard it from you the very first time that we met at that dinner. Hey, you're now on the light side, and you're not on the dark side, almost like Star Wars, with, the dark side of the Force and all that. And I just, I think in many ways there is something to that. Obviously, when insurance companies are making their claims handling decisions, they're doing so in a way that they are trying to maximize profits. And that I'm not going to sugarcoat by telling you that there's some altruistic motives on the part of insurance adjusters to throw money around just because they feel bad for an injured party. In Nevada and probably in most states, there's no concept of third-party bad faith. And so I, as an insurance adjuster, don't owe you squat if you're a claimant suing my insured. There's no duty owed other than to adjust the claim according to the regulations. Mm-hmm. And with that being said, I think I've had a number of different moments in my career as a defense counsel that are similar to the sorts of things that I've done just recently with visiting with my clients' family members that are left behind after they've been killed in a horrific accident. I've had significant interactions with individuals that I'm representing, and my duty runs to them, not to the insurer that is hiring me and paying my bills as a defense attorney. My obligations are to my clients, and those people are real, and they have emotions associated with having been sued and named in a lawsuit. For a lot of them, this is the very first time that they've had any interaction with the legal system, with a lawyer, and they are just as scared and confused as the typical plaintiff may be who's looking to get redress for their personal injuries. Mm-hmm. And so as a result, I've had some moments that have stuck with me and still will continue to stick with me, trying to help people through a difficult patch that they're in when they find themselves on the wrong side of a lawsuit.
And you put a really good point here too, that, and I'm not a lawyer, but possibly from the plaintiff side, there could be an assumption that, they're the only side with emotion because, they've been injured, they've been hurt, and the other side is a corporation. It's very black and white for them and it doesn't matter. But you've been on that side. So what do you have to say about that?
Yeah, absolutely. I think that there, as I just mentioned, there are plenty of individuals that are sued. Now, maybe they're being sued because a plaintiff's attorney wants to defeat diversity. A plaintiff's attorney needs to impute a driver's wrongful conduct to that driver's employer through a respondeat superior claim or something like that. And that's why they've named that individual as a defendant. But let me just say, when you have to represent them and you're answering their questions and they're coming to you because you're their lawyer and that you need to answer their questions because they're scared about, what does this mean for me? Am I going to lose my kid's college fund because I've been sued now? And you have to answer their questions. There's emotions there that are running hot. And oftentimes that is something that is a factor in the way that the case will proceed. You just don't know it because you're not looking at it. You're not in those meetings if you're the plaintiff's attorney. You're having similar meetings on your side of the V and working with your clients that are seeking redress for their injuries that they've suffered. And there's, I think, an incorrect assumption on the part of plaintiff's attorneys to take a position that they're taking and think that there's a void of emotions on the other side.
Mm-hmm. And kind of on this topic, just now that you've been on both sides and you can look at it from the plaintiff side, do you think, well, there probably are, what are some misconceptions that plaintiff lawyers have about the defense?
Well, I guess that there is always going to be lack of willingness to fairly resolve a claim. And what I can tell you is that as a defense attorney, what you're doing, number one, is analyzing risk, and number two, you're arguing with plaintiff's attorneys. But the fact is that you need to report as a defense counsel, and you're going to analyze worst case scenarios and make sure that you bring an umbrella and it won't rain. And that's one of the things that I took pride in, was almost over reporting. And when you're doing that, you're giving everybody the information that they need to make informed decisions. And as a result, you can reach a fair resolution. And so that's what I'm emphasizing as a defense attorney. Now, is everybody doing that? No. Probably there's a fair amount of defense counsel out there that don't take their job seriously, or they're just doing the bare minimum in order to get by. But that's not ones that we want to talk about.
Mm-hmm. So we're going to finish with 2 questions, and we're going to leave all the rest of the juicy stuff for our next episode, which for everyone, we have mediation strategies and demands coming up on the second part of this episode, which is going to be very exciting. But Jim, kind of to finish, what is one, and this might be a bit hard, so I apologize in advance. What's one piece of advice that you could give as a former defense attorney to maybe new or seasoned plaintiff attorneys that you think you should leave them with today?
I think what I would do is suggest to plaintiffs' attorneys that they adequately prepare their clients for a deposition. If the case is in suit, you're probably never going to resolve a case if there's any question about the validity of, say, the liability picture, or there's some question on someone's injuries that they're presenting without having your client deposed. And my advice would be to take a long time to prepare your client for his or her deposition. And when I started this job, I thought I knew how to prepare somebody for a deposition. I have been involved in hundreds. And let me just say that it is a different game on the plaintiff side, and you need to be taking a long time in order to prepare those individuals for the kinds of questions that they're going to face in deposition. And I think mock depositions are probably not out of the question if you have any case that you think you would want to get a decent recovery on.
I think that's a great topic, and we should definitely add that to our part 2 of this episode because that is very, very important. And the last question, and this is going to be funny because normally I'm asking this question to plaintiff attorneys who've been plaintiff attorneys their whole career. It's going to be different asking someone who was a defense attorney, now a plaintiff attorney. What is one thing you know now that you wish you knew 10 years ago?
I would say I wish I knew to switch to the plaintiff side 10 years ago. Because I would have less of the minutia to concern myself with. We're not really looking at the minutia necessarily. We're looking big picture and trying to get that case to the finish line with as a maximum amount of recovery as possible. And that's one of the things that I wish I knew, because I wouldn't have been sweating the small stuff.
I love that. So for people listening, how can they get in touch with you, work with you? Maybe they have some questions after this and they think, you know what, there is an expert that I can reach out to that can help me. How do they do that?
Yeah, I would say just shoot me an email. It's Jim, Jim, @claggettlaw.com, CLAGGETT.com. Excuse me, CLAGGETT law.com.
Perfect.
And I'll encourage people to just shoot me an email because I'm always on there. And I'd love to hear from folks that may have insurance questions, particularly on some thorny issue of coverage, because that's kind of what excites me. I'm a little bit of a nerd like that, and would love to hear from folks if they're out there and struggling.
I love that. And we are so happy to have you on the podcast. Thank you, Jim, for your time. And these are the fun things that you get to do now. You're on the plaintiff side. I won't say the light side because we did cover that, but on the plaintiff side. And we're definitely going to have you back for part 2 where we can cover all the stuff we didn't get to cover today, which is a lot. So thank you to all of our listeners. I know you're going to love this episode. This is now our part 5 of Confessions of a Former Defense Attorney. We're going to go into part 6 very soon. But thank you once again, Jim. I really appreciate it.
All right. Thank you very much for having me.